Do I have to have something here to make this work?
I don't
Oh,
think,
cool. There we go. I guess I got to go back. There. Good morning. Is the photographer here? I want a picture with Wilbur. Okay, now Wilbur and I, we go back over 35 years. We're not normally on the same side of the table, and we probably don't go to the same nightclubs. However, we do have a shared passion of over 35 years each in the same industry, and we both have a reputation for breaking balls. So Wilbur, come on, let's get a little picture. So as I was putting my presentation together last night, I decided to shit-can the update to the phase one and try to stay more in line with Wilbur's talk and David's talk. I call it the kind of new phase one because it's been around for a year now. But the bottom line is that this is a remediation conference. And so I want to talk specifically about the relevance of phase ones in the consulting assessment remediation arena. And it's going to come up in a couple of ways that are going to be consistent with the talks you've already heard. One is with regards to de minimis discharges and interim source removals, which has become the preferred way in Florida that we deal with just about any accident. We don't tell DEP about it. We don't tell DERM about it. We just go out and try to clean it up within 30 days, and it winds up being filed away. Next, because of some subtle changes we made at ASTM in 2021, the concept of cleaning up to CTLs, especially commercial CTLs, which are risk-based, is not going to fit in the way it used to ASTM phase ones, and I'll explain that in a moment. And then finally, going forth on what David had to say about emerging contaminants, I want to talk a little bit about how that phase one is going to somehow fit in over the next year or so, or 2 years with PFAS. So let's just start out with the concept of a remediation based on a de minimis discharge. So basically what 62780 says is that if you can clean it up to CTLs and in 30 days, you don't have to report it to anybody. Okay? So DEP is not involved, nobody's involved. You clean it up and it's done. If it's petroleum related, instead of doing the 30 days, they talk about how many gallons. Is it less than 25 gallons? And of course, that's always a crapshoot in itself. Whether it was or wasn't really doesn't matter. But the bottom line is, either way, you're only cleaning up to CTLs, which typically are going to be, commercial industrial-based CTLs, not residential, and there's going to be no reporting. Now that raises a bit of a problem for us when you think about the owners of the property versus the purchasers of the property, okay? So for the owner, he hires a consultant and says, can you get this cleaned up? Do I have to get DEP involved? Sure, we can get it. We don't have to get DEP involved. We can clean it up. And so basically the owner hears it's cleaned up when they're done, okay? Which is fine. However, the purchaser, if they find out about it and they get their consultant involved, find out it's not cleaned up, it's cleaned up to commercial. And of course, commercial satisfies the DEP, which in general terms would also mean the consultant did an adequate job, but not if you're the person buying the property thinking it's clean. So one of the issues with self-directed cleanups, and that's what I'm seeing more recently, is that we got to pay attention as consultants to the documentation and relevant data that's available associated with whatever that de minimis cleanup is. And the question is, who's paying attention? Because ASTM says you have to identify the documentation, but you don't necessarily have to opine on how well it was performed or whether it was adequate in terms of the assessment or whether they got closure samples to prove that they finished it. None of that's required in a phase one. So think about it. Because there's no documentation, it's a de minimis cleanup, we basically have a cleanup with no reporting and no documentation. which is a precarious position for both the buyer and the seller at that point. And then the last thing we got to talk about is the control. Well, what is the control? Well, it used to be, the idea was we cleaned it up to commercial, and as long as it stays that way, there's no harm, no foul. But one of the subtleties that ASTM did in the last go-around is we actually replaced what was called a property use restriction, which is now called a property use limitation. And notice that the new definition says it's a limitation or restriction on current or future use of a property in connection with a response to a release. Okay, a response to a release. Well, what does that mean? We don't clean up property to commercial standards because of a response to a release. We do it because of zoning. It's zoned commercial industrial. Well, what ASTM's saying now is zoning doesn't count. And we have a number of reasons why zoning doesn't count. But you can imagine that creates a chasm between the people that are on the consulting side for the owner and the people that are on the consulting side for the purchaser. And so the bottom line is, with no implicit controls, okay, the idea of what is clean is way up in the air, and it all depends on which side you're representing. And because there's no notice, there's no registry of a control, there's nothing else out there. The only way you'd find out is if you specifically asked, and the owner, through their real estate contract, had an obligation to tell you that there had been some sort of release on the property in the past. No different than what's happening with sinkholes, right? There's an obligation. If you've had a sinkhole claim on your property, you're supposed to advise the purchaser that you've had such. So the bottom line here is that you can't use the concept of a controlled wreck anymore for these types of cleanups. You used to be able to, but because the cleanup isn't based on a institutional or engineering control, but rather is based on zoning, you can't use the CREC definition, so you're left at that point with a wreck, with a recognized environmental condition. It's the only thing that you have left to you unless they actually cleaned up to residential, and let's face it, nobody's cleaning up to residential. So what we have now, and what I'm seeing just now coming through the courts, are instances where self-implemented or self-directed cleanups were performed. They were only done to commercial, which I'm not saying is wrong, but it doesn't result in a cleanup. And now you've got an owner that says it was clean, the purchaser buys the property, finds out that they've got a problem because they're doing some sort of redevelopment or something, and that's where the litigation starts. And of course, the owner goes back to their consultant and wants to sue them for telling them it was clean when it wasn't, okay? And we even have situations where the purchaser is pissed off at their consultant for a flawed phase one. So it's making for quite a problem out there. Now, why did we remove zoning? Because we were concerned about how many instances now where zoning is changed, and typically when there's a zoning change, there's no environmental element to it. It goes before the hearing master, and it's all about concurrence, right? But the bottom line is they really don't look at environmental stuff. And then we've got instances where, for instance, companies are putting in daycare facilities for their employees and so forth without any, knowledge or understanding of environmental impacts. So just to kind of tie this all up, from a practical standpoint as the consultant, one of the things you got to think about is how is the owner put on notice that the cleanup isn't clean? In other words, if you're going to perform it, what do they want? Do they really want it cleaned up to clean, or are they okay with a cleanup that satisfies the DEP? Because those are two separate questions that need to be answered, okay? The next thing, are you going to put the purchaser on notice about the cleanup? Well, that's a matter of contractual considerations based on the real estate document. Most of them require some sort of duty to report, but not always. Florida's still a buyer beware state, so in some instances you wouldn't find out about it. What documentation do you have available, and how much effort have you put into looking at it to determine whether even the cleanup to commercial was done appropriately? Is there closure samples? Did they do enough at the beginning? Did they look at all media, all the Wilbur stuff, you know? How many times? Wilbur will get you. I guarantee if you miss a media or you miss a contaminant, he'll get you. And typically what happens in these kinds of self-directed cleanups is they miss a lot of stuff, okay? And is there a restriction, and does it still apply? Because things are constantly changing. Now, from a client consideration, okay, there's a number of things happening. You don't have a regulatory sign-off, so they need to understand that. It may or may not have been cleaned, but what you don't actually have is anything from a regulator. Now, you could open up that can of worms, but I guarantee you're not going to like the outcome, because they're probably not going to be satisfied with the assessment, and you're not seeing any kind of no further action or site rehabilitation completion order in any kind of reasonable time frame that suits your real estate transaction, okay? So it really comes down to, well, for the purchaser, what's your risk tolerance? You know, what do you plan on doing with the property? How effective do you need the cleanup to be, okay? Is it going to be consistent later on? Is it practical to go back in and do any kind of additional cleanup? But these are all questions for the purchaser at that point. And my point I'm making is you better have that conversation before they buy the damn thing. Because once they got it, it's a big problem for everybody now. Not only for the owner, but also for the new owner, okay? And that's without even discussing landowner liability protections. In the few instances, we actually have a client that cares about one of the landowner liability protections to CERCLA, there are continuing obligations that are necessary. Well, if you didn't even know there was a cleanup, or you didn't find out till after the fact, you're not going to be able to get your landowner liability protection because you didn't even know. So I see Wilbur mentioned agricultural uses, which again are also not a rec because CERCLA had pulled the ordinary use, proper distribution of fertilizers and pesticides out of the release definition. So there's another example where your phase one may opine that there's no rec, but that doesn't mean it's clean. Doesn't mean it's okay with the regulatory agency, and it certainly doesn't mean it's going to be okay with the prospective buyer. Okay, so then moving on to David's talk with PFAS, okay? What have we talked about so far? What are we going to do with this stuff? Well, from a phase one standpoint, from an ASTM standpoint, the simplest answer is we're going to do absolutely nothing. It's not a hazardous substance. Therefore, it doesn't fall within the four corners of the standard. It's not a rec. Done. Okay? However, it's not as simple as that now. And the reason it's not as simple as that is because what's happening, I'll move on. I'm going to try to make up some of our time so that we stay on time. So what's happening now, though, is that you're hearing more and more about PFAS in the environment and more about it being on the regulatory radar screen. That matters because if you go back and recall what we did with petroleum products in the ASTM standard, we've got sites now already throughout the country that have some sort of state or federal standard. Not federal standard, but a state standard. We have that federal, what is it, 70? You throw it all in a box and figure out whether it's 70 or not, right?
Exactly, or 40 if it's by itself.
There you go, okay? No one knows what that means, but that's okay. Hey, we all make a lot of money off no one knows what it means. So if you think about what we did with petroleum, petroleum wasn't a hazardous substance either, right? The lobby had pulled themselves out of those regulations. So how is it that ASTM threw them back in? Well, we did it for two reasons. One was when the Superfund amendments came out, the Superfund amendments said, whatever it is you're going to do to demonstrate all appropriate inquiry, you all know it as a phase one, you need to do it consistent with good commercial and customary practice. And when we developed the first phase one in 1993, we said, well, of course people look for petroleum. So it's good commercial and customary practice to do so. Therefore, we're going to include it in the phase one. So to this day, if you look at a phase one, it always says hazardous substances and petroleum products. Hazardous substances, because that's what CERCLA says we got to look for. Petroleum products, as Sarah said we could. It was good commercial and customary practice. And then the other thing was that we recognized because petroleum could be enforceable under other state laws, it made sense to put it in. Well, if that's the case, then we should be able to throw PFAS in too, for this exact same reasoning. The idea being it's already on the radar screen at both the state and federal level. Some states even have standards already. So you can do that, and if that's the case, you got a wreck, okay? Now, what I would recommend is if you're going to go that direction, I'm not a big fan of it, but the kinds of litmus tests, if you will, that you would want to consider is, first of all, are you dealing with a property where it's obvious that there would be PFAS? You know, you're at a fire training facility or something. If it's obvious, that would make good reason to throw it in the same way you do petroleum products, okay? If you're in a state that has actually established standards, Florida hasn't yet, but if you're in a state that has, that could also be a good argument for it being good commercial and customary practice in that state. The same if it's regulated that way in that state. So the point is, if you want to call it a wreck, I think there's an avenue to do so. I'm not a huge fan of it until it becomes a CERCLA hazardous substance, but I could certainly see an avenue to do it and make a solid argument that it should be there and that our clients should be on notice, especially on sites that are obvious. And then if you just want to bail out and you don't want to call it a wreck, you don't want to call it no wreck, you don't want to do anything, remember we still have the business environmental risk angle that we threw into the standard in 2000 where we said, listen, it's a non-scope issue. However, it's enough on the radar that we want to make sure our clients are aware of it. And therefore, we call it a business environmental risk. Now, the only thing I'll tell you about that is that oftentimes sophisticated clients, attorneys, or large developers don't want to see business environmental risks in their phase one because it opens up for questions that they don't want to have to answer. And that's their right. Business environmental risk is not a part of the standard, okay? But it can be included through contractual arrangements if that's what you want to do. There, I wanted to make up some time so that we keep it moving. And plus, I'm just full of shit anyhow. So whatever you need.
Nick, to the contrary. Thank you so much. A few observations on Nick's presentation, and then a question, and then we'll open it up to the audience for questions. First observation is in the state of Florida, even though there are only provisional numbers for PFAS, DEP considers those provisional numbers to be enforceable, meaning they have the rule of law and they can bring enforcement actions. Now, there's a pause legislatively at the state level with respect to enforcement, but only against local governments and private and publicly owned treatment systems, water treatment systems. For private sector-owned PFAS sites, the state doesn't have any restriction whatsoever. So that's the first observation I'd like to make. The second observation I'd like to make is really more of a question, and before I ask Nick the question I'm going to ask, and then Wilbur, I have a question for the audience. Among the private consultants here, how many consultants are using the 21 standard as opposed to the 13 standard at this point? 21 standard? And the 13 standard? Okay, less are using the 13 standard than the 21 standard. In my experience, most consultants are still using the 13 standard. Nick, my question for you is, what standard should consultants be using? And then Wilbur, my question for you is, does DERM look at the standard used by the consultants when they review phase ones? And does DERM have a position on which standards is appropriate, or is the county agnostic? I'll start with you, Nick.
So as far as ASTM is concerned, once the 21 standard came out, that's the standard to use. Any standard prior to that is a former standard. However, in practice, EPA still acknowledges that both the 2013 and 2021 satisfy all appropriate inquiry. So I would say until EPA formally, and they haven't done it yet, formally come out and say 2021 is the only one available, I think you could technically use either. The only challenge is if you're using 2013 and there is definitely some fundamental changes, especially in concept, in 2021, you could fall, into a situation where people ask you Monday morning quarterback, why are you using an old standard? I just recommend you make sure you clear it with your client. Whatever they're satisfied with should be good enough.
Thank you. Miami-Dade County term does not approve an ASTM Phase 1. We fulfill the obligation to provide comments if there are missing elements of the ASTM Phase 1. So we provide, based on the records available or our evaluation of the site, elements for the consultant to add to their evaluation in order to satisfy the comprehensive evaluation of potential chemicals of concerns based on that historical or current land use.
Wilbur, thank you. Questions? I think I saw a question right here in front. Yes.
Hi, Nick. I have a question. So, like you mentioned, the EPA didn't adopt Phase 1. I think they issued a notice earlier this year. Is there a specific reason they didn't adopt it, or they just need time to look into it?
It's so hard to hear because of the echo.
Yeah, no, I was having trouble.
Can you ask that one more time? We didn't hear you, Fang Mei.
So you mentioned the EPA didn't adopt the 21 standard. Is there a specific reason they didn't adopt it, or they need more time to consider that?
Okay, yeah. Why is it that EPA, why is it that it hasn't been adopted yet? Well, that answer is actually pretty simple. At one point during the comment process, EPA had signed off and was ready to approve 2021, and the U.S. Department of Commerce was concerned about PFAS. And the way they read the standard, they were concerned that it was going to actually be incorporated as a contaminant of concern that's relevant to the standard, and they were afraid of what that was going to do in the marketplace with brownfields redevelopment and other things, especially since we didn't have a standard. So once EPA clarified that PFAS is a non-scope and it's outside the standard, U.S. Department of Commerce withdrew their negative, and now it's just a matter of it being put into the Federal Register, which is, it could be next month, it could be 6 months.
There were also private sector objections that were filed during the comment period. As Nick said, EPA was prepared to adopt a final rule approving the 21 standard, and during that interim phase, while the final rule was pending, comments were filed by private sector, public sector. There were several lawyers very involved in brownfields redevelopment who felt that the standard as proposed was, the final rule approving the new standard was insufficient, and EPA took those comments to heart, pulled the approval, and a new interim final rule is pending. What we're hearing from EPA is that the final rule should come back out again shortly and be approved by second or third quarter of next year. Which is why this, which is why this question is so important, because for purposes of all appropriate inquiry in the innocent landowner defenses, you need to have EPA signing off on the rule. That's what the statute requires. That's what CERCLA requires. So even though ASTM has approved the new standard and released it as of November, EPA hasn't signed off on it. So you have two separate protocols. You have the EPA-approved protocol for all appropriate inquiry from 2013, and then you have the industry standard for 2021, which leaves private parties utilizing the standard caught between the old and the new.
And you still have all appropriate inquiry. EPA's rule, which you could use, and don't use ASTM at all.
That's right. Any final questions for any of the panelists before we go to break? Very good. Thank you, panelists. This has been a wonderful discussion.